We had a couple comments during the break, and I want to mention to you, someone has heard some rumors that Fannie and Freddie is going to come out with some additional guidelines for the use of powers of attorney. And they may be driving the use of having legal descriptions in powers of attorney. So stay tuned on that. There may be something more to go in that. I know you're getting settled in here. We have quite a bit of material to cover yet. I haven't seen anyone fall asleep yet. I'm really excited about that. I had a realtor. We don't have any realtors here, do we? No? I had a realtor fall asleep in a closing once, and it was really fun. It was after lunch, and he'd had a good lunch there, I'm sure, and he sort of drifted off to sleep and started snoring. Not real loud, just sort of purring. And I'm like, should we wake him up? Nah, let him sleep. And it was really fun. Right at the end of the closing, you know how you look around to see if anyone noticed that you nodded off? And he thought he had totally pulled this off. It was awesome. So I haven't seen anyone do that yet. So one of the biggest topics that we deal with in the area of abstract examination is divorce. And so we need to spend a little bit of time talking about the implications of dissolution of marriage for abstract examination. And the first thing I want to mention is that, again, the couple is married until the decree has been issued. So very, very important. And we see that with some frequency is there'll be a conveyance that doesn't properly show that. Dissolution decrees as muniments of titles. So there are two ways that real estate can be conveyed in the course of a divorce. So one is the decree itself can serve as a muniment of title, right? It can act like a deed. The other approach is for a quitclaim deed to be required. Right? So sometimes you have situations when you're examining an abstract where you see the decree says the real estate shall be conveyed by quitclaim to Jane Doe. But there's never a quitclaim. So do we have a problem with that? Some attorneys will say there was evidence from the decree itself that there was a conveyance contemplated. I take the position that the court wanted to have a quitclaim deed. And if there's no quitclaim deed, we have a problem. So if the court is requiring a quitclaim deed, I'm going to require a quitclaim deed. Right? So it's sort of a simple rule. But sometimes you'll see a situation where there's a lack of a quitclaim deed. I actually recommend to my family law attorney friends to use the decree as a muniment of title because it's one less step that we have to deal with later on. The thing to keep in mind is if the decree is going to serve as a muniment of title, the decree has to refer to the legal description of the property. And every once in a while, I'll see a decree, and it'll have the street address of the property. You would never have accepted that on a deed. You shouldn't accept that on a decree. And so I've provided you in the materials an affidavit to tie that up for the court to sign off on or someone to sign off on saying they're the same. And I provided you with some sample language there on page 15 for that. As a reminder, if there is a quitclaim deed that's conveying the real estate, no transfer tax is required. All right, and then we have some issues with respect to judgments. And one of the things to keep in mind, the bottom of page 15, let's say you have a situation where there is a judgment, let's say for property settlement to Jane Doe. John Doe is getting the property. Okay? So Jane Doe is supposed to quitclaim her interest in the property to John Doe. But she has a judgment in her favor, let's say for $15,000. What is the effect of that quitclaim deed as to the judgment? Any thoughts on this? Does a quitclaim deed convey that judgment interest in the property? Or does that judgment stick, we use the metaphor of the sticks, does the judgment remain in the hands of Jane Doe? You have a thought? Okay. What if the quitclaim deed makes no recital? It's silent on the issue of the judgment. does the quitclaim deed have the effect of giving up that judgment? And the answer is attorneys will differ on this. Okay, so the question is, or the comment is, he thinks that the quitclaim deed would maybe inadvertently convey that judgment. And I agree with that. But still, if there is a judgment, I'm still going to require a release, even if there's a quitclaim. A well-drafted quitclaim deed is going to say, I'm conveying my interest in the property subject to the judgment. And that way it's clear to the world that Jane Doe is retaining that judgment interest against the real estate. Sometimes you'll see a situation where there's the judgment, there's the quitclaim deed. Did Jane Doe inadvertently give up her interest in the property? Should I raise an objection? And I'm going to. So just people differ on that a little bit. Okay, so let's talk about judgments in general. Judgments are liens against real estate for 10 years. They are a common issue. And so sometimes a judgment comes up and it's the wrong party. We see this with some frequency. And so an affidavit of identity is oftentimes used to address a situation. If you happen to be the poor schmuck who has the name of John Smith and you live in Des Moines, Iowa, and there are 50 judgments that show up against you, then that's going to be a problem. You might think about changing your name. And so an affidavit of identity works well for that. One of the biggest areas of change in real estate law came when we changed the way that we handled homesteads. And I would spend more time on this, but I want to just give sort of an overview of this. Bottom of page 16 is where we start. Judgments do not attach to homestead property. Not only are they unenforceable, they don't even attach. So we used to have an approach where we would plat the homestead. It was a fairly cumbersome process, and many clerks' offices did not have the proper indices in order to handle that. So the legislature came up with a really wonderful tool that allows us to designate a piece of property as homestead property and file a demand on the judgment holder that gives them 30 days to file an enforcement action of their judgment against the property. If they fail to do that, then the judgment then is no longer considered a lien against the real estate. Let this sink in, folks. This is cool, and it's really easy to do. So I've done a number of these, and I've given you all the forms that you need in the materials to be able to do this. It is a piece of cake. You don't have to get service on them. You use the last known address in the court files. You send that off, 30 days, you're done. So that's a pretty neat tool to be aware of. Make sure that your lenders are aware of that. So Exhibit 17 in your material is a sample demand. So the question is, can you just do this by affidavit? You know, what if the homeowner says, hey, I live here. It's my house. I've been here for 30 years. It's my homestead. Or if the attorney does it. And actually, I would say, no, I wouldn't accept that. And here's why. The code provides a way of resolving this. And I think to step outside that, it really becomes a due process issue for the judgment holder. That judgment holder has a potential property interest in that real estate. And if we're going to remove that, I think that judgment holder needs to be afforded notice to be able to say, that guy doesn't live there. It's a rental property. Right? So I think we're going to run into due process issues if we don't follow this process of giving notice. Thanks for asking that question. It makes sense to do that. And the other thing that's sort of cumbersome about this or weird is the Homestead Tax Credit. I get asked this all the time. Well, Tim, I signed up for my Homestead Tax Credit. And that makes sense to ask that, but they're completely different things. It's unfortunate that we have this thing called the Homestead Tax Credit. We should have called it something else. So thanks for asking that question. Judgments also might be addressed if they're against a buyer with the use of a purchase money mortgage. the face of the mortgage has to recite, this is a purchase money mortgage. So make sure that that recital is on there. Now, here's sort of a practice pointer. John and Jane Doe buy this property. There was a judgment against John Doe. Now, 3 years later, they want to refinance. They got to deal with that judgment, right? And so, or they're going to sell the property. So you want to make sure that it's clear, hey folks, you're buying this property with the use of the purchase money mortgage. Makes sense to do that, but just bear in mind, this may be an issue when you go to sell the property. Child support, big issue. You see this happen all the time. Remember, you have a 10-year window of looking back. So what if you have a kid who's 23 years old? Well, 10 years from the date when the last payment was due at age 18, you have that additional 10-year window that you have to pay attention to. So that's a trap for the unwary. So pay attention to that. I've given you some sample language for that. Calculating the amount owed, I've given you some sample language of how to lay out the numbers in your title opinion to help a closer to know what steps need to be taken. Obtaining a release, this is one of our challenges. If you do have a situation where we do need to get a receipt for the child support, what happens when the ex-spouse doesn't want to sign? Right? That happens with some frequency. You mean you would like me to help you with a transaction? No way. And so in a situation like that, you can really be stuck sometimes. One stick that you can always use is you can threaten to take them back to court. And the court can make a determination that the payments are current. And this is where we also want to talk to our family law friends when they're advising their clients. Make sure that those child support and alimony payments are paid through child support recovery or through the clerk of court. I can't tell you how many situations I've had where the guy comes by my office 4:55 on a Friday, furious with me that I'm making him get his ex-spouse to get this receipt. He says, look, she's never going to sign this. And the child support record isn't current because a couple times I went over there to pick up the kids, I just gave her the cash. Right? It was just easier to just give her the money I owed her. She was holding my kids hostage. And you have to explain, well, I don't have any way of documenting that. And so in some situations, people have to almost pay twice. That's not very fun. So have good conversations periodically with your family law bar. In my county, about once a year, I get invited to come and visit with the family law attorneys. They get together on a monthly basis or every other month, and they pull me in and we talk about real estate implications of divorce decrees. And so have that kind of relationship where you can help your family law attorneys do this the right way. Okay. Child Support Recovery Unit, their website I think is getting a little bit better over time. One of the controversial questions we've had on page 21 is whether child support for post-secondary education is a lien against real estate. And the best that I can tell you is that you want to have familiarity with what the local practices are. If I see a decree that requires John Doe to pay $300 a month for post-secondary education expenses, I'm going to require that child, because the judgment is now in favor of an adult, to sign off on that receipt. There are some attorneys who would say, no, Tim, that's not right. You don't have to do that. But that's my opinion. Find out what's the status in your local area. Conveyance by warranty deed by both parties. Say you have a situation where John and Jane Doe remain on the title. They're going to hold title for a bit longer. They're going to sell the property, and there's a judgment in favor of Jane Doe. Do you need to get a release from Jane Doe if they're both going to sign a warranty deed? The answer is no. The effect of a warranty deed is you're conveying all the interest you have in that property, including any judgments against each other. So in that situation, that warranty deed relieves us of the need of getting that receipt. Okay? Now, here's one that is a really interesting situation. Okay, back to reading. Bottom of page 21. Occasionally, a dissolution decree will require one of the parties to make installment payments towards a property distribution. For example, the details here are important, so lean in on this one. John Doe owes $10,000 to Mary Doe. with monthly payments of $500 beginning the month after the entry of the decree. This looks very much like child support or alimony payments, and it would seem reasonable to only have the judgment debtor current on monthly payments. But that's not the way these are treated. The entire amount of the property settlement, because of the certainty of the amount owed, we know the full amount of the lien is a lien against the real estate and must be satisfied. And this comes oftentimes as a big surprise, because John Doe, he didn't anticipate having to pay all of it when he conveyed the real estate. He thought he was doing the right thing by making these monthly payments on the property settlement, and you're the bearer of bad tidings, where you say, look, the entire $10,000 is owed. So be careful as a title examiner not to pass on this just because you have a showing that three $500 payments were made when really the full $10,000 is a lien against the real estate. Right? They're treated differently. Yes, sir? Could you restate the question for me? Great question. So, and if I don't restate your question correctly, help me out on this. So, again, a judgment is only a lien for 10 years. So we have situations where you have installment situations where we get beyond that 10 years, we don't have to worry that far back. For example, let's say you have a child support situation and the child is now 17 and it started when the kid was 3. I only care about the last 10 years. I don't care about those buckets that were created back then. I only care about the last 10 years of buckets. When it comes to property distribution, the full amount of that property distribution is a lien immediately upon the filing of that decree. Does that help to... Did I answer your question? 10 years afterwards, the lien is gone. So if you're examining an abstract, so thanks for helping him out, you're tag teaming on the question. If you're examining an abstract and the judgment itself is over 10 years, we don't have to worry about it. Because the property was conveyed, the lien effect wasn't there any longer. Right? Thanks for asking that question. Yes, ma'am. Yeah, the question is there any flexibility with this situation? The answer is yes. In fact, I talk about this. That judgment is like any other interest. It can be released without being satisfied. It can be subordinated. Absolutely. So I have done that in situations where the property settlement was this huge amount, and we subordinated that judgment. Lenders sometimes have to get their brain around this because that affects the income-debt ratio of the borrower. But as long as the numbers work out from their perspective, we don't care about that. I tell people all the time, that's the underwriting side. All I care about is the title. I have to know at the end of the day that mortgage is in first position. If we get there by virtue of release, if we get there by virtue of subordination, I don't care. As long as mortgage is numero uno, we're good. Thanks for asking that question. Okay, we're going to shift gears to estates. And I think Chapter 9 of the Title Standards is a really well-written chapter. And so basically what you do as an examining attorney is you figure out what kind of situation do you have in the abstract. Is it a situation where the individual has died intestate? Title Standards explains that. Situation where you have an executor. We have that. Situation where you have a surviving joint tenant. It explains that. I've provided you with a chart on page 22 of the exclusion amounts for federal state tax. Wow. There was this John Wayne movie where they painted this red line on the floor of the cell because there wasn't any bars. You know what I'm talking about, that movie? There's a little red line right there. I'm not crossing that line anymore. Okay. One of the things you have to pay attention to as an examining attorney is whether the executor has authority to convey the real estate. In most of our modern wills, we're going to authorize the executor to convey the real estate without court approval. But don't presume that. You want to look in that abstract entry to see whether the attorney has the authority to convey the real estate. The presumption is that they do not. So if it's an older will and there's no recital of the authority to convey the real estate without court approval, then we have to have the court approve the sale of the real estate. Don't miss that. Easy to do. Okay, death certificates. I like seeing a death certificate there. If you have a situation where the person died out of county, sometimes we use affidavits to verify some of these things. Estate planning concerns. Sometimes you see a situation where the title is in John Doe, and then the mortgage then is given by John Doe and Jane Doe, husband and wife. Is that a problem for us as examining attorney? Does it matter to us that John Doe is actually married, but the title is only in John's name? Is that a concern for us? No, it's not. He can own the property in his own name. He doesn't have to. Now, if you're doing a refinance transaction, you might want to bring to the attention of the lender you're writing this for, hey, just giving you a heads up, it appears here that John Doe is married. If you would like me to do a quitclaim deed to establish a joint tenancy, let me know. So it's not an objection. But folks, I've had a lot of positive feedback from my lender clients who were actually sort of tightening up something very important for this couple. 95% of couples in Iowa own their real estate in a joint tenancy. And so if you have a situation in the course of refinance where you discover that he bought the house, got married later, that could be a real help to this couple if you make that as a suggestion. Is it a title objection? Absolutely not. But you're helping these people out. The other thing that's sort of similar that we touch base on, when I close a refinance loan, I always ask the couple or the individual, have they signed up for the Homestead Tax Credit? Now, is that a requirement for what I'm doing? Absolutely not. But folks, I have seen so many situations where the person never heard of the Homestead Tax Credit, or they heard about it and never bothered to sign up for it. And so it's an extra benefit that you bring to the process. So if you close loans for a living, you're closing refinance loans, it's not going to be in the abstract. It doesn't matter to the lender. Just ask the borrowers if they have signed up for the Homestead Tax Credit. That's an extra thumbs up they're going to give you. They'll be appreciative of the fact that they put that in place. Okay. Let's shift over now to page 24. And we're going to go through a variety of other situations with abstract review. Variations of entity name. This comes up with some frequency, and the title standards has done a nice job of explaining to us in what situations we need to raise an objection for a variation of a name and situations where we can pass. So familiarize yourself with that portion of the title standard. So for example, if we have a situation where First World, the original title holder, let's say it's a mortgage. Mortgage was given to Hometown Savings Bank, Inc. And now they're First World Universal Bank, Inc. Right? They're a little bigger, right? A little expansion. You want to show an FKA, right? So tie those things up with references to FKA, NKA. Variation of individual names. This is also something that sometimes I see lawyers raise objections for wanting to show connections between certain names. I'm like, no, the title standards address this. This is not an objection. We don't need a curative affidavit. The title standards has given us leeway to pass on those things. The exception is going to be when person literally changes name. Maybe there's a marriage or maybe there's a divorce. Now we need to make sure we tie up those variations. So in the conveyance, you want to see how the title is vested and how title is currently being given, and you want to make sure that there's a connection between those two. Okay, mortgages. This is a big topic and lots to talk about. So underline on page 25, this is number 2, all mortgages must be released, subordinated, or assumed. Again, Mortgage assumption is pretty much a thing of the past unless it's a family transaction. So, released, subordinated, or assumed. Somehow, we've got to get the new mortgage in first position. Sometimes we see old mortgages that have not been released. Bear in mind, sometimes a mortgage is old enough that it becomes what's called stale. My kids say my jokes are stale. This is a different application. A mortgage is stale if there's no recital of a maturity date if it's 20 years old. Now, it's sort of interesting. Most mortgages now are 30-year mortgages. So it's sort of curious. At some point, that title standard may need to be revisited to see, does that title standard really fit with our modern mortgage instruments? But 20 years from the date of the mortgage, unless there's a maturity date. If there's a maturity date, it's 10 years beyond that maturity date. Okay? And if it's beyond that, then it's stale. Now, again, if I had a title opinion to write in that situation, I would go ahead and explain, I am not requiring a release of this mortgage because it is now 6 months past being stale. Nothing further is required. Right? That's insurance. The notes that you write, the title opinion you write is the best insurance you have. Open-ended mortgages. I have to tell a story here. It's been a while since I've told this story. So a number of years ago, my staff came into me and said, Tim, I'm trying to get a release from a lender, and they've been unwilling to provide me with that release. And I think you need to call them. Okay, great. Call them up. I said, lender, hey, we paid you the money. It's been several months now. We need to get that release. And the lender said to me, Tim, I'm sorry to be the bearer of bad tidings. We will not be releasing this mortgage. I said, oh, really? I gave you the money. He said, no, this was an open-end mortgage. And as a result, there needed to be instructions to close the line of credit to release the mortgage. And what's more, that borrower has gone out and used that line of credit again, and they have defaulted. This is why I keep a spare pair of pants in my office. So I'm very lawyerly and poised and cool, and I ran like a bat out of hell to the file to open this thing up to see, in fact, was there any indication that this was an open-end mortgage? Looked at the title work. There was nothing there. Abstract. I might have had some kind of notations. There was nothing there. On the payoff, sometimes a lender will send a payoff and it will indicate line of credit mortgage. And there was a box that says, if this is a line of credit, this box must be checked. And the box was not checked. So I'm doing my little fiesta dance over to the fax machine. We still used, again, fax machines at this time. And they put in the fax machine, sent it off to this guy. I waited 5 minutes, and I called him up. I said, you need to release this thing. Because there was nothing to indicate to me as the closer that this was an open-end line of credit. So when can I get that release? And the response was, see you in court. Well, as it so happened, the people that I did the mortgage for, there was a default there, and there was a battle of foreclosures going on. Now, the end of the story is that they were able to work out a resolution. It is amazing to me that we have not had a case go up on appeal on open-end line of credits because there's enough money involved to make it worth someone's time to hire a lawyer to take this case up on appeal. I've been involved in 2 or 3 of these where was pulled in to advise on this. But this is a critical issue. Now, I thought we'd resolve this several years ago. I told this little story, did my little Mexican dance, and I thought this thing had gone away. But in the last few months, I have had situations where I've seen Form 900s where I learned after the fact that these were open-end mortgages. And I never knew about it until I went to pay off the loan. And the abstractor said, Tim, we don't designate on Form 900s it's an open-end mortgage. Now lean in on this part. This is really important. That creates huge vulnerability for everyone. Okay? So I'm so glad we have a whole bunch of my abstracting friends here, because I need you to hear this and let this sink in. If there's an open-end line of credit mortgage or some kind of mortgage that requires that additional instruction, we're counting on you to show that in your abstracting, whether it's a Form 900 or whether it's a full abstract. We're counting on you because this is a food chain. The lender who's going to close the loan to pay this off is relying on us as the attorneys to indicate it's a line of credit mortgage. They're going to rely on us because sometimes the lenders screw this up, and on their payoffs, they do not indicate it's a line of credit mortgage. So in a perfect world, the payoff from the lender would show in big, bright, blinking lights, open-end mortgage. And so there are instructions from the borrower to close this line of credit. A line of credit is nothing more than a credit card that's attached to the property. That's all it is. So you can pay your credit card down to zero. This thing is still valid. So to make this thing go away, it's not just paying off the loan, follow me, it requires those written instructions. Title Guarantee has one of the most beautiful things called the Mortgage Force-Off Program. I love this thing. My wife cannot understand why I'm in love with this thing. I said, look, this is awesome, because we can force these defective mortgages off title, except if it's an open-end line of credit. So apparently, I think this is coming back into our conversation. So newer attorneys, be very vigilant to note in your title opinions whether it's an open-end mortgage. Abstractors, be vigilant to look for that and point that out to us. I believe the standard of care that a court would adopt, I believe this, is that the abstractor will need to show if it's an open-end status mortgage. I believe the standard of care for the lawyer is to make an extra effort to show it's an open-end mortgage. So lawyers, if you're not showing this as an open-end mortgage, that's risky business. I think you could get sued over something like that. I really do. And so go to the extra mile and show it's an open-end mortgage, because that closer who's going to rely on your title opinion needs to know if it's an open-end mortgage. Questions? Comments? Anyone else been stung on this besides me? No? Yes, ma'am. Where it was not shown the title opinion, you got stung. And if you have title issues and it's about you and you don't want to share that, you can say it's one of your friends, right? We're cool with that. We're cool with that. Anyone else have a friend have this happen to them? Okay. All right. Let's go on and talk about restrictive covenants on page 26. And it's fortunate we have Jim Nervig here with us today. Jim is on the legislative committee of the real estate and title law section of the Bar Association. He's worked very hard on this, so if you have additional questions, you can ask him. If you're watching this on videotape, his cell number is... Just kidding, I won't do that to you. But this is an area that we need to pay very close attention to, and here's why. These restrictive covenants end in 21 years, unless there's been a process where a verified claim has been filed to extend the covenants. So you could have a situation where you have, let's say, a really nice subdivision that's got $500,000 houses. And eventually these restrictive covenants expire. Mrs. Smith goes to walk her dog. And when she goes to walk her dog, her friend next door says, "Hey, take a look at this. I bought the original Partridge Family bus. Look at this. It's right there in my driveway. And it's going to be there now forever." Well, the next thing Mrs. Smith is going to do is she's going to call her lawyer and say, "We bought this nice house in anticipation that there were restrictive covenants to limit things like this. I don't want to live next to the Partridge Family bus. It's actually sort of a cool-looking bus. But anyway, I don't want to live next to that. At some point, the Des Moines Register is going to cover this when this goes to court. So I'm hoping that we get something tied up in our legislature in this coming session or the next one where we address this. This is also an issue for condos. So if you're watching this on the video, this may have already been addressed by the time you are watching this. But stay tuned for that. And that's why I put that language in my title opinion, to make sure that we're giving people a heads up about restrictive covenants. Developers' agreements. Developers' agreements sometimes are, in essence, liens against the real estate. They are obligations that have to have a release from the municipality. Oftentimes, developers' agreements are secured by a bond. If it's secured by a bond, we don't have to worry about it. But if a release is required, pay attention to that. Make sure you get that particular release. Mechanic liens. Mechanic liens are a subject all by themselves, something we have to watch for in our title work. I don't want to go too much into the weeds on this, but just know that that's something that you're watching for as an examining attorney. Mortgage foreclosure, bottom of page 26. I want to talk a little bit about foreclosure. The good news is the foreclosures are declining, somewhere in the vicinity of 25-30% decline from last year. I'm happy about that, right? But still, we're going to be dealing for some time with the implications of foreclosures in abstracts. A couple of points to make, and some of this is not in your outline, so you might actually have to take a few notes on this. One question I'm looking for when I'm looking at a foreclosure is, did the right party foreclose? It is very common to have a situation where you have the wrong entity of record filing that foreclosure action. And you might wonder, why is that happening with such frequency? The underlying paper gets transferred and sold, and the world never knows about this, right? So that underlying loan was purchased by lender X, but it's still the original lender that still has the mortgage. And we wonder why the disconnect. So the nice way of curing that is an assignment. So there needs to be an assignment of record to allow that subsequent entity to file the foreclosure. We want to make sure that assignment is effective as of the date of the petition for the foreclosure. Okay, so that's the way we connect the dots there. A second thing that I'm going to look at is, do we have the right defendants in the action? Was the spouse named and served? Right? So pay attention to that. Are there junior liens that, where the junior lien holders were not named in the petition? I see this with some frequency. Not as much as I used to. There used to be some other law firms that were handling foreclosures that were quite honestly very sloppy, and they're now gone. The remaining law firms that are handling the bulk of the foreclosures do a fantastic job, and I'm willing to go to the mat if anyone says the difference. We have very good foreclosure law firms in Iowa. But every once in a while, one of these things slips through, and there'll be a junior lien holder. It might be a mortgage holder. It might be a judgment holder that is not named. How do you know where they have to be named? This is where you look at the lis pendens date. Okay? So anything that's of record prior to the lis pendens date that judgment holder, that junior lien holder, has to be named as a defendant in the foreclosure. If it does name, that junior lien holder is named, the foreclosure has the effect of scrubbing the property free of those junior lien holders, if what? If they're served, and one more thing, what is the effect? Is it the decree itself? Sheriff's sale. That sheriff's deed is the final step. So sometimes we have situations where there's an interruption in the foreclosure proceeding, and there was a mortgage that was changed into a judgment. See, that's what a foreclosure does. A judgment is turned, a mortgage is turned into a judgment. And because the homeowner waived their homestead right to that property, that's what gives that mortgage any teeth. The judgment then can be used as a lien against the real estate that can be force the property to be sold, even if it's their homestead. Okay? So if the decree has been filed, but you haven't reached the sheriff's sale, those junior liens are still there. If the judgment was filed after the lis pendens date, we don't care about that. We don't care about that. Okay? Other things I look at, sometimes there'll be a situation where that sheriff's deed will convey the real estate to XYZ Bank as trustee. And this is a point where I get a little bit picky, because I don't think that that's a valid deed. But you see that with some frequency. Because there isn't enough information to know they're a trustee of what. Right? So if sheriff's deed to XYZ Bank as trustee, I'm going to say, hold the bus here, folks. I want to have a new deed. I want to have some clarification. Or, at the very least, in the subsequent deed, I want to have something that ties up the fact that the grantee in this should have been the XYZ Bank as trustee of, in this long recital of the name of that trust. So make sure there's a connection. Make sure we're connecting the dots in that situation. There's a lot more we could talk about mortgage foreclosure, but let me see, is there anyone else that have any issues they want to share on foreclosures? Yes. Okay, are there any other questions on mortgage foreclosures? No. So the question, and the video, I could just give a different question, and the video people wouldn't know that. I thought of that before. So the question is, and I will restate the question, is if you have, so you have, the title is, we have Mortgage 1 and Mortgage 2. Mortgage 2, the loan defaults, and they're going to foreclose. And in their petition, they recite in the petition that they have the superior mortgage, even though you can see very clearly that they don't. I actually have a problem with that petition. Right? We've actually had quite a conversation among lawyers on the effect of this. So my position is, even though I don't like those pleadings, if bank number 1 has been properly served, they know about this rodeo, and there's a decree, and the time for appeal is passed, I think they're out. I think the effect of that decree has the effect of quieting the title even as to that prior mortgage. Now, that was not a position that I had in the past. In fact, there's a lawyer in the room that he and I have gone back and forth on this very subject, and it's been very fun. But on this issue, I think now the settled position is that the effect of that decree does quiet title against the first mortgage holder. Thanks for asking that question. Yes, sir. Missed it, ma'am. Yeah, that's a great question. So, do you have to have a satisfaction of this judgment? I'm glad you asked that question because I meant to talk about that. So, if we have a situation where the foreclosure process has been stalled out, they reach some kind of resolution, the decree has been entered. Yeah, let's walk through this. So prior to the filing of the decree, you still have a mortgage. That mortgage must be released. Post-decree, you no longer have a mortgage that has to be released. Let me say that again. Post-decree, you no longer have a mortgage that has to be released. And I see sometimes attorneys will ask for that, and it's really not necessary. Because after the decree, the mortgage has now been converted to a judgment, and now that judgment needs to be released. So sometimes I see situations where they've had a workout, and they've released the mortgage, but they haven't released the judgment, and that's a problem. So that judgment has to be released. Okay? Thanks for raising that. All right. Contracts. You know, I have been predicting for a long time that interest rates would go up. For about 5 years, actually, I've been predicting this. And now no one ever listens to me. And so I've been predicting interest rates at some point. They just have to go up. And so if interest rates go up, I've been predicting that now we're going to go back to using installment contracts. And there's been some slight increase in the use of installment contracts, not so much because of interest rates, but instead because the underwriting requirements for getting a loan have gone up. And so now John and Jane Doe, they actually have to have some evidence of ability to repay the loan. They're leaving Iowa State with a bunch of debt, and they can't qualify for that $500,000 house. Go figure. And so instead, if they can find a seller who's willing to go along with this, they can enter into an installment contract and start making those payments and eventually refinance once they get some of that student debt paid off and they're developing some equity in the house. So in some ways, it makes some sense. But it hasn't been a huge tidal wave of this. Now, at some point, interest rates will go up. So as examining attorneys, you need to be vigilant to understand how installment contracts work when you come across different variations of things in the abstract. I'm not going to go through this in great detail. I've given you sort of the different variations of what happens when you have an assignment of the contract by the contract vendor, and I have an explanation of what you look for when it's a conveyance by a contract vendee, the buyer. What is it you need to see in the abstract? So just know, oh yeah, I have that in an abstract. Go back and look at Tim's materials. It lays it out exactly what you need to see. Right? So if someone comes to you and they need help with that, this material will tell you what you need to do in order to make that transaction work. Contract forfeiture on page 28, I do want to really emphasize something that's of great importance for an examining attorney. We had this come up in Ames, and it was a very ugly title issue that we spent a lot of time on. So let's say we have a situation where we're conveying real estate to John and Jane Doe on contract, but things aren't working out, and they're not making their payments. And they decide to say, hey, look, you know, Smiths, this isn't working out, and we just can't make our payments, and we wanted to buy this $500,000 house, but it just didn't work out. So our lawyer drafted a quitclaim deed in lieu of forfeiture. We've signed it. Here you go. Okay? Now, at first blush, this sort of makes sense because in the back of your mind you think, well, there's this thing called a deed in lieu of foreclosure. This is just a deed in lieu of forfeiture. They actually sort of sound alike. So, yeah, this will work out. Thanks for the deed. Have a nice life. The problem with this is that judgments against the contract buyers are liens against the real estate. So in addition to the fact that the sellers didn't get their payments, guess what they also got when they got that quitclaim deed? They got some judgments. And those are liens against the real estate that they now have to deal with. And those John and Jane Doe, they're now long gone. And they have to deal with these judgments. So if you're going to do a quitclaim deed, maybe there's a need for speed, and you want to do a quitclaim deed, that's okay. This is where you want to call your friendly neighborhood abstractor and say, I need a quick lien search against these people to make sure that they're conveying this real estate free and clear of any garbage. Okay? So that's when you can do a quitclaim deed in lieu of forfeiture, only when you have the abstractor make that search. And I'll come to you just a second. The proper way of doing this, in my opinion, is the contract forfeiture. I really like forfeiture. And that sounds sort of mean. But again, what forfeiture does is it has that scrubbing effect on the property. It cleans off all that garbage. So it's a very powerful thing. And so I like to get property back by virtue of forfeiture rather than that quitclaim. Yes, ma'am? Yeah, the point is outstanding. when you're communicating with an abstractor, you want to be very clear as to what it is the purpose of that search, so they know to do the proper search. Thanks for asking that question and making that point. Anything else on contracts? Here's an extra sort of bonus situation. Do you need to examine an abstract when someone's going to buy a property on contract? Yeah, you do. You need to pop the hood and look at that engine just as much at that situation as if there's a lender. I had a situation a number of years ago when I was representing the contract buyer, and I asked the attorney for the contract seller, said, so at what point should we expect the abstract? And the attorney said, well, Tim, you don't need to do a title opinion on the purchase of the property on contract. You just do that when they refinance down the road. I said, well, I still really want to examine this abstract. So it turns out, begrudgingly, gave me the abstract, continued, examined it, and it just so turned out that his clients were also buying on contract, and there was a prohibition on their ability to convey the property within a certain period of time. Now, the attorney didn't know this, and he felt terrible that it looked like he was trying to keep me from knowing this. But the moral of the story is that we need to pop the hood and examine this abstract on a contract purchase just as much as when there's a lender financing the transaction. Okay, so always examine the abstract. Okay, easements, bottom of page 28. Easements are really important. And there are all kinds of easements. And as I alluded to earlier, they're created in a lot of different ways. Sometimes they're even created on plat maps, which I really don't like because it makes it more difficult to find them. So I like having instruments that are captioned easements for that kind of conveyance. It makes it easier for the abstractor to find, makes it easier for the attorney to find. So be diligent. Sometimes these easements are created in different places. One of the things that we're seeing recently, particularly with issues of access easements, is the issue of maintenance. And a lot of lenders are saying, look, you've done a good job of having an easement for a driveway, but that's not good enough for us. We want to have a maintenance agreement attached to that. So we're seeing that with a greater level of frequency. Affidavits of surviving spouse. The affidavit of surviving spouse comes up because there's oftentimes a failure when there's a situation, John and Jane Doe own the real estate as joint tenants. John Doe dies, and there's never an affidavit of surviving spouse filed. And the problem with that is that when Jane Doe conveys her real estate, what happens to the tax records? Well, John Doe's name is still on the tax records. So you could have a situation where this takes place, and in many kind of courthouses, the recorder's office and the auditor's office are just down the hall. The recorder's office can say, hey, John Doe, he's dead. Take him off of the records. But they don't do that. They require this to be on there. So sometimes you get a call from an angry buyer who says, hey, how come this dead guy is still on my tax records? He's still on the title. No, he's not on the title. He's dead. You can't take it with you. He's just on the tax records. And so an affidavit of surviving spouse or surviving joint tenant would be needed. So it's not a title defect, but as you're examining an abstract and you see a situation where John Doe has died, so there's a death record, but there's not been an affidavit of surviving spouse filed, then you should still go ahead in your title opinion and ask for that. Is it a title issue? No. But it's going to screw things up later on, and you're going to get phone calls. So where possible, go ahead and file, encourage people to file that. Yes, sir. Right. Yeah. So this issue, as the gentleman brings up, is also true in divorce situations where the clerk needs to file a clerk's change of title, and sometimes that gets forgotten. I just dealt with this last week, and so I end up drafting these things for free because it's going to take more effort. I can just do this faster than I can explain this to two realtors. So sometimes some additional type of thing is needed to take that name off the tax records in a divorce situation or in a surviving joint tenant situation. Thanks for raising that as an issue. Okay, yes, ma'am. Oh, yeah. So bankruptcies are a drag. And I meant to talk about this, so thanks for making sure I didn't pass over that. It wasn't intentional. So in a bankruptcy, we have a situation where judgments are discharged, but the underlying lien is not. Now, if you were to ask me, to be a very good question, Tim, why do we have a situation where the judgment is discharged, but the underlying lien is not? I would not be able to give you a very satisfying answer. I don't understand this myself. I think it's odd. And if I become king, we're going to make the effect of a bankruptcy decree that discharges the debt, it will also have the effect by law of discharging the property from that lien. But that is not the law in Iowa, and this trips a lot of people up. And so, so what you're faced with then are you're still dealing with a judgment on property, and a judgment holder just got kicked in the teeth. Now, I have been successful in going to the judgment holder and saying, "Look, I know this is awkward. You just had your debt discharged in bankruptcy. That's not fun. I've had that happen to me. But would you be willing to sign a release of this property so that it doesn't cloud this up for future owners?" And I've actually had some success with that. If you ask very nicely, you might find the judgment holder willing to sign a release of that. Not always. They may be just mad. Yeah, thanks for asking that. Pardon me? This question is, would Title Standard 1.1 cover that? The answer is no. That's a good question. And there might be, eventually we might reach a decision that it does, but the problem is we have a judgment that is statutorily a lien against that real estate for 10 years. I don't know anyone who has passed on a situation like that under 1.1. And there isn't a good argument to be made for the ability of that judgment holder to enforce that. Where's the reasonable probability of litigation? But I have not seen 1.1 being used as a means of rectifying that situation. Has anyone else used 1.1 in that situation? I haven't seen it, but it's a good question, though. Thanks for asking that. So this might be a situation where a homestead situation. We file a demand, declare the property's homestead, file a demand. This might be the place where you pull that out of the holster. That's a very effective tool. Absolutely. Bob asked a really good question. The bankruptcy trustee has the authority to release the property from that lien. And so you can always go back and have the bankruptcy attorney go back through that process and get the property, because they have jurisdiction over everything. And so they have the ability to release that property of the lien. Thanks for asking that. And that is done. Yes, so if there is an effort to do that, there has to be some notice, and so sometimes there's some costs involved that is an issue. I've had that come up where there's a complaint because the bankruptcy attorney who charged the nice flat fee is now wanting some more money to do that extra procedure. Yeah. Right. Yeah. So the bankruptcy attorneys, either they don't want to include that in their package of services they provide. So it is something we have to pay attention to. So watch for those bankruptcies. Okay. I'm going to shift gears now back to... Oh, yes. Yeah, great question. So if an easement predates the plat, does it have to be shown? And it's a bit tricky business because, in my opinion, a well-done platting procedure will show those prior easements. I really think they need to. you've got a big natural gas line stretching across that property. That may have well preceded the platting procedure. It should be shown on that plat map. And so I'm looking for that as an examining attorney. Thanks for raising that as an issue to make sure those are shown. And what's hard, too, that easement may give you, this easement is across the southeast quarter of the southeast quarter. Does it affect Lot 4? I don't know. I'm still going to show it in my title opinion and say you should confirm whether this easement affects the subject real estate. Thanks for asking that question. One more thing I want to point out on page 29. There are a number of resources that, as a newer examining attorney, you want to make sure you're aware of. Besides the title standards, it's an awesome resource for us. The Iowa State Bar Association has a real estate manual. It's a little bit dated now, but it's still an excellent resource. If you don't have that, you should have that on your desk. The thing that's really hard to get a hold of now is Marshall's Title Opinions and Standards. It's second edition. And it's hard to come by this. And newer attorneys somehow need to beg, borrow, and steal to get one of these. So if you're a retiring attorney at some point, sell this to the highest bidder. You'll make some good money. But that is a wonderful resource. I refer to Marshall's often. It's hard to find someone who's done more for real estate law in Iowa than George Mattson. And if you haven't had a chance to meet him, he has done so much for us as real estate lawyers. The debt we owe him, you can't even put a price tag on this. His work is just invaluable. And so many times I read this in the middle of the night, and I think there's a lot of wisdom in that particular comment, the way he crafted some of his answers. So, very important resource. The other thing is, if you are all involved in real estate as an attorney, you want to be sure you're a member of the real estate section for $15, which is hard to believe. That's only thing it costs. You'll get the listserv and be able to participate. And it's so encouraging to see the attorneys weighing in on these issues on the real estate listserv. So you want to take advantage of that. Also want to mention there is an upcoming seminar. There are 2 seminars you'll see me at every year unless I'm sick. The Drake seminar in the spring and the Iowa seminar in the fall. So I bookend the real estate season with those 2 seminars. And it's sort of fun. You catch up with people. The Drake seminar will be on March 7th. So I want to go ahead and give you that date. March 7th is going to be a great program coming up this spring. So be sure to attend that if you can. All right, I want to shift gears back to my opening material and talk about organization of title opinions. As time goes along, it's going to be imperative that you develop a system that allows you to have a good organization for these title opinions that you're drafting. And so I want to talk a bit about that. First of all, what information do you want to keep? And the answer is everything. So if you've taken notes, you want to scan it, you've done some research, you scan it. What I use on my desk, I have a desktop scanner. So after I do my title opinion, I run it through the scanner. And so on my computer, I have the title opinion and I have the scanned version with all my notes. So if I get a call down the road from someone that wants to ask a question about a title opinion I did 10 years ago, I can pull up any title opinion notes I've ever done in a matter of seconds and be able to walk through why I made that objection or passed on an objection. Folks, the notes that you take are the best insurance policy that you have. And so keep everything that you've relied on. Now, lawyers will differ in terms of the way in which they create their folders on their computer. I want to show you what I use. I found this to be effective. Other lawyers in my office use a different approach. So I've broken it up into 3 groupings of the alphabet. And then within that, I have by lender. And then within that lender, I have by year. So if you call me and say, Tim, could you look up a title opinion you did in 1999 for the XYZ lender? In a matter of seconds, I can pull up that title opinion and the underlying notes. And so that's a very valuable resource for you to have on your computer. Okay. Sections of final comments. I know that I've really gone deep with you on a lot of just sort of nuts and bolts of how to deal with mortgages and easements and covenants. But the stuff I want to talk about now, I think of is almost as important. So the first thing I want to talk about is walking through title objections, collaborative versus adversarial approaches. This is a funny story. A couple years ago, I had an attorney issue a title opinion where somehow, and I don't know how he knew this, he knew that I was the prior examining attorney. And he sent this title opinion out, and there's this major objection that he raises. And he really went out of his way to make me look like an absolute schmuck for not raising this objection. He sent this title opinion, of course, to the lender, to all the realtors, and he even found a way to send this to my mother. I don't know how he got her fax number, but he sent it to my mom. And so I look at this, I'm like, wow, we really sort of went overboard to make Gartin look like an absolute idiot. Now, it may well be that I am an absolute idiot and I made a mistake. But he really went out of his way to make this point. You know how lawyers will do this. The lawyer obviously failed to you know how this goes. So I went back to my notes, I pulled them up, and I said, hey, what did I do on this? Did I miss something? I went through and looked back, and there are my notes, and I carefully laid out the reasons why I passed in this objection and the authority for this, and the lawyer was just wrong. He just made a mistake. Now the temptation comes in. You know where I'm going, right? Do I find his mother? It was so tempting, right? So instead, I said, okay, this is a teaching moment. And I'm going to do for him like I wish he would have done for me. Pick up the phone. Say, hey, I read this title opinion, and I don't know if you're aware of this, but there's some authority in this. This really is not a valid objection. Oh. Okay? So, when we have situations where there are title objections, let's find collaborative ways to resolve these things. Every once in a while, I know this is hard to believe, abstractors, but every once in a while, I'll find an abstract with a mistake. I know it's hard to believe. And what I do is I call the abstractor and said, I think you missed something on this. And you know what they say? Thank you. We'll fix it. And who knows that I found this error? Just me and the abstractor. And there are attorneys that go out of their way to throw the abstractor under the bus, right? And that drives me crazy, right? Don't do that, lawyers. Pick up the phone and just call them. And they'll be more than happy to resolve this. And here's the other reason why, is that abstractors are going to far more save your backside than you will theirs. When you send that filing over, and there's a mistake in what you sent over, they can either call you and say, hey, hotshot, you didn't have the legal description on this. You didn't have the marital status. Should I still file it? Or they can go ahead and just record it. And then you have to deal with it later on. So if for no other reason than just your best interest, you want to have a collaborative relationship with the attorneys that you practice with and with the abstractors. We like abstractors. They do a lot of hard work, and it's very demanding sometimes to go through these documents, and every detail counts. They have tremendous liability exposure, and so let's not take opportunities to throw them under the bus. Okay? All right. Now, solving title problems. When you have a title issue that you've raised, you want to try to do your best to find out what the status of the transaction is. Okay? So let's say that I've examined an abstract and it came to me late, and I examined it, I issued the title opinion today, Thursday, and they're trying to close here as soon as possible. Okay? And they've asked me for my help. The first thing I want to do is I want to find out when is this closing and what is the rate lock on the loan. Because if we're facing a rate lock, that adds a whole other dimension to this transaction, because if you're going to extend this closing, then someone's going to have to pay some money to to extend the rate lock. So you want to find that out. It's also valuable to find out, are there any particular pragmatics to the situations with these buyers? Somebody's moving in from San Francisco, they have 9 cats and their mother-in-law in the back of this minivan. You may want to try to expedite that transaction, right? So find out, when is this thing closing, and what are the issues with the rate lock to try to make everything work. So that's an important thing. And what we do in our office is we said, look, this is the problem. How many different ways can we find to solve that problem? So there may be a situation, let's say there's a defective assignment. Mortgage was given to lender A, the release comes from B, and there's no proper assignment from A to B. Well, if that mortgage was improperly released, one of the things we can do is we can force it off title, right? And so that's one thing we could do. A second thing we could do is we could try to get a corrective document. So as a strategy, we're going to always try to employ several different approaches to solving the problem in hopes that one of them catches, right? So we don't check one box and then go to the next, then go to the next. No. We try the shotgun approach to resolving these title issues. Next, what to do when you're stuck. This happens sometimes. And of course, it always happens on a rush title opinion, and the people you would normally go to aren't around. And so what you want to do is you want to have attorneys that you can lean on in those situations, right? Because there will be a situation where that bird flies up, and you don't know if it's a hen or a rooster, and you don't know whether to pull the trigger on that. So you need to find people that you can go to for help with those situations. Now, someone asked me a question. I want to double back and talk on one thing about. They said, Tim, why do we have all these problems with defective releases and assignments? Why can't lenders get that right? And the answer is, this is a result of title insurance. Again, we're 2% of the population. This tail will not wag the dog. Lenders don't have to give that level of service and accuracy because title insurance doesn't require it. In Iowa, we actually care that it's right. And we're not going to carry the day. So the standards that lenders have for doing the assignments and releases correctly, in my opinion, is abysmal. But nobody cares. Right? So if you're wondering, why are we doing all this work with corrective assignments and releases, that's why. We're in a broader context, and folks, we're not going to change that. You can call up that lender, and you can chew them out for not getting a proper release in, but they won't care because you're only 2% of the population. Right? So anyway, that's an important thing to understand. Timeliness. Linda Berg, with Title Guarantee, went on a road trip a number of years ago. And she went around to lenders, and she said, help me understand, what is it we need to hear about this title guarantee process? And she got an earful. And she came back to Title Guarantee and said, folks, we need to make some changes. One of the feedback points that she got an earful on was the issue of timeliness of attorneys and also of abstractors. So it is very important, if we want to avoid calls for title insurance in Iowa, we have to make sure this process works in a timely fashion. So abstractors have to turn their work around in a timely fashion, and lawyers, you can't take 30 days to draft a title opinion. Right? I try to turn my title opinions around in 24 to 48 hours. And sometimes that means some late nights, but that timeliness issue is very important. On the back side of the loan, making sure you're getting your final title policies out in a timely fashion is also very critical for lenders. So the timeliness issue is really important for us today. Okay, I have other things I can talk about should I need to, but I wanted to allow some time here for some additional comments or questions. We have some attorneys in this room that have decades and decades of experience examining abstracts. So if you have some thoughts, questions, this is a good time to share those with the rest of us. It's a wide open field. What advice, maybe I should say this, if you're a senior attorney and you have some advice for a newer attorney, what kinds of advice would you give? As you're thinking about that, there's a question over here. So the question is, if there's a defect in the acknowledgement, totally wrong party that's released the mortgage. Yeah. I think that's probably falling into the Title Standard 1.1 issue, is that if we've gone 10 years and that release is there, the chances of anything happening that are pretty remote. So I would say that's a situation where you're okay. Was there another question? Or open up to general comments, questions. Yes, ma'am. The question is, why are we allowing Social Security numbers to be on declarations of value when tons of people have access to this? And it is goofy. I don't have a good answer for you on this. We use the declaration of value for 1099s. That if we have to file a 1099, that's our source of the Social Security number for the seller. We oftentimes have it from the buyer because of their loan application that we have access to. But the DOV provides a nice recital for both Social Security numbers. There has been some limited discussion of changing this because of people's concerns with identity theft with Social Security numbers on DOVs. And so maybe Jim will make a note of this and change this for us. But the problem with Jim going to these seminars is he leaves with this long laundry list of things that we wanted to change. Other comments or questions? What advice would you have for new attorneys? I surely didn't cover all of it. Any other advice? Yes, Jerry. No. So Jerry makes a good point. We want to be very detailed oriented when examining abstracts. So maybe some basics on this. If you are too tired to properly examine the abstract, it's time to go to bed and do it tomorrow. I do not advise examining and drinking. It may not be against the law, but you may find yourself with a missed mortgage. So if you have a stack of abstracts to examine, you think this pain might be eased with a beverage, be cautious on that. I don't advise that, by the way. Thanks, but be very detail-oriented. That's right. Yes, Matt?
I think it's very helpful that when there's objection raised or a clearance item, that you put down what your clearance expectations are.
Yeah, and so Matt raises the point. Again, be generous with advice about how to clear these objections. A lot of attorneys have bypassed the title opinion process and are just issuing commitments. That drives me nuts. Sorry if you do that. We issue commitments, but we also issue a title opinion. No one's charged extra for it. I like the title opinion format for this very reason, because the title opinion gives us greater flexibility and latitude in explaining these things. The other thing I want to make mention of, and thanks for bringing this up, Matt, I no longer use the fax machine for sending out my title opinions. What I do is I email the title opinion out. Now, when I send that email, if there is some kind of issue in that title opinion that I particularly want to bring people's attention to, in my email, I will put that in there. I will say, I want to bring your attention, C1 of the title opinion has a child support obligation. So not only do I put this in my title opinion, I go the extra mile and put it in the email, the body of the email, to bring this to the attention of the realtors and the lender to get them started on this, because it may be, sometimes title objections can be resolved very quickly. Sometimes they take a long time, and we don't want to presume that it's a quick one. So that's an extra little practice pointer. But thanks for bringing that up, Matt. Other advice for newer attorneys? Yes, Bob. Yeah, legal descriptions do change. Bob is emphasizing again, keep those notes. So I scan these things. They're part of my computer, but we have a backup of this. So if my office burns down, I'll lose a few pictures. That'll be a bummer. I'll lose my copy of Marshall's. But the title opinion notes are off-site, and I can rebuild those in a heartbeat. So that's really a good practical point. Yeah. That's a really good practice pointer. The context, you want to watch your favorite movie and try to examine it at the same time. Probably not a good idea. If it's in a day when the phone is ringing off the hook, it's a recipe for missing something. So having a block of time. There are times when I just leave the office and I say, I'm out of here. And I'm going to go to a coffee shop and I just sit there and I examine abstracts. That's a very good practical point for new attorneys. Thanks for bringing that up. Yeah, Matt.
I've got another, they're kind of related. First, what do you tell your clients about owners? About creating owners every time you available. And the other small question is, if you have a buyer flow of an abstract from the seller of real or brings it in, usually things will make up that transaction that they think they're going to be doing with the abstract they actually brought in.
Okay, you've asked two good questions, and I have a funny story on the second one. So the first one is what? Yeah, owner's policies are wonderful things. A couple months ago, someone asked me to look over a settlement statement from the state of Washington, and it's probably a $200,000 house. The owner's policy was $1,000. And the lender's policy was $1,000, and the owner's policy was $1,000. Now, either we're not charging enough, which may be the case, or they're getting ripped off. So this owner's policy is a huge, huge deal. And in Iowa, it's free, as long as there's a lender's policy. And if it's a cash transaction, I'm recommending it anyway. It's $110 for transactions $500,000 or below. So it's a very important thing that we recommend that. I love title guarantee for putting that in place. And every time I do a closing, I highlight for people, this is a free owner's policy, and I give them the brochure from title guarantee because I want to sell that. So thanks for bringing it up. The second one, it's a good war story. I had, so I always tell people how to sign up for Homestead. In fact, I give them a little document on how to sign up for Homestead, so make sure they do this. So this guy bought a really nice house in this big subdivision, and he calls me up, and he said, Tim, I went to sign up for my Homestead, and they told me that I actually owned the house next door. Now, I need to develop a filter because I just do. And so I said to him, so how do you like the house that they say that you bought? I thought that was funny. I thought that was hilarious. He did not. What had happened was the realtor, when they started this process, they gave us the wrong abstract. They had a stack of abstracts for the lots in the subdivision. They pulled off the wrong one. He thought he was buying lot 4. All the time it was lot 3, and we didn't find out until he went to sign up for his Homestead. Thankfully, it was a fairly easy fix. He was not amused. In fact, even now is not amused. So we do try to make some kind of connection and make sure that we're lining those properties up. Other comments or questions? That's great. Yes, sir. So the question is, how do we navigate as attorneys this issue of who is our client? And thankfully, the vast majority of issues that a buyer is going to have with respect to the title is going to be in congruence with the lenders. They want to make sure they have clear title. Usually, I never meet the buyer. So there's not even a potential for that kind of discussion. So goes back to the discussion of the Basel case, which again I think is a really important case. If you're examining for a buyer, you're going to have a different set of lenses. You're going to want to know what is their intended use of the property. So you're going to think about that differently than for a lender. But so oftentimes, if I see an issue that I think would be of importance to a buyer, I'll make sure that I put that in the title opinion. For example, in my covenants, if we have a situation where the covenants require only owner-occupied properties and no rental properties, I'll probably put a note to that effect in my title opinion. Do I have to? No. This is just an extra help. But a lot of times, borrowers aren't seeing that title opinion until closing. Realistically. Yeah, thanks for bringing that up. Yes, sir. Yeah, so the point was well taken. We actually have some formal classes on legal descriptions. I have not taken that class, but if maybe the abstractors would remind us when we have one of those classes coming up, we'll put that on the real estate listserv and try and promote that. Thanks for raising that as an issue. Oh. I agree. So I'm going to finish on a story. So over here, I'll finish on a story. So in 1989, I got on an airplane with my wife. We were going on our honeymoon to San Francisco. And I'm sort of a curious fellow, and I struck up a conversation with the fellow next to me. And I asked him what he did for a living. He said, well, I'm a psychologist. Oh, that's sort of interesting. What do you do as a psychologist? And he said, oh, I work for the airlines. I said, okay, I'm trying to think about, maybe advertising, or what does a psychologist do for airlines? I said, so what exactly do you do for the airlines? He said, well, I have sort of a unique job. He said, my role as a psychologist for the airlines is I go around to wherever there's a plane crash, and I debrief the volunteers and emergency workers who are there to pick up the pieces. So now I'm really curious. And I say, and the reason why he was there was in 1989, there was a plane crash in Sioux City. Remember this, 110 people died, terrible situation. And I asked this question, and I'm so glad I did. I said to him, you've done this now for a long time. Have you noticed any differences around the country in your work? And he said, it's funny you should ask this. That was a fact. Are you ready for this punchline? Okay, that would have been cool. I don't know how that's going to turn on the videotape. Anyway, so I asked him, I said, have you noticed any regional differences? And he said, it's funny you should ask this. He said, when a plane goes down in California, people will travel from 50 miles away to loot at the scene of a plane crash. He said, when a plane goes down in Iowa, people come from 50 miles away to help. That was a very nice story for me to hear. It didn't tell me anything I didn't already know, but it was affirming for me to hear this from him, that this is the kind of people we are. I'd like to tell this story on occasion because we need to apply that same good attitude, that same helpfulness and community-oriented spirit in a way in which we deal with title work here in Iowa. We're all in this together. There's a collaborative nature. It doesn't have to be adversarial. And I hope that that's a helpful story as you think about our roles together. This has been really, really fun to spend time with you today.